Yes.
40.
Item number 40.
40. Next week.
Next week.
1.
Item number 40. 40.
14 and 15.
Okay. 1 4. You inform the other side?
Yes, madam. Hardship.
Okay. Mr. Khatonier, learned standing counsel for the contender. With consent from the other side, press for listing the matter in the next week. Pair allowed, recess and list the matter on.
Lordship.
Could we fix a date?
Yes, Lordship. He may fix on Friday, Lordship, as because some urgencies. No, Lordship. If Friday, nahi bol. Bahut din hoy gol dada. Aapko time dobo apna loge. Ye karo. 25th. Yes, ma'am.
25th.
I left first.
May please, your lordship. Lordship, I beg to mention item number 2 of the daily list.
Yes.
Lordship may kindly pass over the matter for the day, as my senior Mr. A.A.R. Karim is suffering from fever.
Mr. Your name, please?
G.K. Gogoi.
Mr. G.K. Gogoi, learned counsel, appearing on behalf of Mr. A.A.R. Karim, learned conducting counsel for the petitioner. Press for listing the matter. After?
Lordship, any date?
Next week.
Lordship.
Okay. After a week, pair allowed, recess and list the matter on COVID 27 February.
Obliged, Lordship.
Lordship. But the person of others, Lordship, I beg to mention item number 7 and 10, Lordship.
7 and 8.
10, Lordship. 1.
7 and 10. 7 and 10.
Lordship.
Mr. Your name, please? B. Devri, learned counsel, appearing for
I put the response number 2, 3, and 4.
respondent number 2, 3, and 4. With consent from the other side, press for listing the matter after
15th of March, Lordship.
after 15th of March. Next month. Okay. Okay. Fair allowed.
Second March. Okay, there is a date, Lordship.
Interim order pass earlier shall continue.
Both the cases, Lordship. 7th.
Both the cases.
May I please, the Lordship? I beg to mention item number 16 of today's daily list, madam. The matter has become infructuous, madam. Item number 16, madam.
Item number 16.
Yes, madam. The petitioner has died, madam.
Okay. Mr. S. Hazarika,
Yes, Hazarika.
learned counsel for the petitioner submits that this matter become infructuous and as such the same may be closed. Accordingly, taking note of the submission of Mr. Hazarika, learned counsel for the petitioner, the CRPIU number so and so starts closed.
I'm deeply obliged.
May I please, your lordship, I beg to mention for system 1 IA in RSA lordship.
When?
Wednesday lordship.
Next.
Sorry.
Yes.
Wait, please, your lordship. I beg to mention one RSA for listing. This
Yeah.
matter is no, the matter is pending for hearing since long, so kindly the matter may be listed. for
Hearing.
Order.
Oh, hearing.
Yes.
Hearing or order?
Order so that we can fix a date for hearing.
Okay.
Yes, lordship.
Okay. If it is already in hearing column, then only it will be listed under the said column,
Okay.
not in the order column.
May I please, Lordship?
Thank-
Consult the other
Obliged.
side. I like to back to mention item number 9, SDL. Definitely adjourn.
Mr. Your name, please?
H3.
A. Setri,
Petitioner.
learned counsel, appearing on behalf of.
Petitioner.
Your name is not there.
For RLE. I'm appearing for
Learned
RLE.
counsel, appearing on behalf of Mr. R. Ali, learned conducting counsel for the petitioner. Price for listing the matter after
4 weeks.
4 weeks. After 4 weeks, pair allowed. Recess and list the matter after 4 weeks.
Lordship, interim order will be
You
extended.
obtain the consent from the other side.
Yes, your Lordship. Lordship, interim order may be extended. For
Interim order pass earlier. Pass earlier shall continue. Okay.
May it please, your lordship. Lordship, I'm praying for listing of the CRPIO in the admission column, lordship.
When?
On 19, lordship.
Okay.
Update.
Yes.
Should lordship pray for listing of a RSA in the order column for tomorrow, lordship.
Tomorrow is hearing.
Case is speak from 19th February, Lordship. May kindly fix.
18 Wednesday.
Okay.
Yes.
Please, your lordship, I beg to mention a transfer petition civil,
Hmm.
fresh matter. Lordship, tomorrow the case which I am seeking for transfer is listed before the Honorable District Judge in Jorhat. So if the court allows, it may be listed tomorrow. There is some urgency in this case. Already the case has become ex parte against me and tomorrow it is fixed for evidence.
Okay.
Tomorrow.
May I please? Chief, I beg to motion RSA for listing
Under which column?
hearing, Lordship.
Hearing column. Okay. Take a date from him.
19, Lordship.
May I please, your lordship, I beg to mention AB matter, my lord. Oh,
AB?
yes, my lord, because in this matter, my lord, you have already, my lord, rejected the petitioner bail application earlier. So I request you to, my lord, kindly list this matter in your court.
AB matter according to roster.
Yes, my lord, but in this same affair, my lord,
No,
you-
you go and mention it before the senior bench who has been taking the matter
but my
and ask the registry to list the matter here because it was earlier rejected. There is already one circular to that effect.
yes. Objection.
You go and mention there.
Oh, yes.
May I please, your lordship? Lordship, I beg to mention for listing RSA for hearing, two RSA, lordship. And both the parties, both the matter, parties are same, lordship. So.
Okay. When
That
do you
will
want?
come together, lordship.
In
Next
the month
week.
in the month of March, not in the month of February. Take a date from him as per your convenience.
Items for motion, item number 1.
May I please, your lordship? Lordship, in this petition, my lord, lordship, for quashing of the, my lord, FC civil case number 448 of
No,
2025.
you tell me, is there any provision in the CTC for quashing of a matter? Is it?
Lordship,
You show me any provision? Can you?
lordship, I will verify, my lord.
You will
Yeah.
verify.
Yes, my lord.
No, before filing the petition, you ought to have verified the provision under which you have prepared this petition.
Yes, lordship.
In CRPC, there is one provision, 482 for quashing.
I approached before, my lord, Article 227 of read it, my lord, 19(4) of the Family Court Act, my lord.
Pardon?
19(4) of the Family Act.
19?
19, Section 19(4) of the Family Act, my lord.
Family Court Act.
Family Court Act.
It is provided.
Yes, lord, sir.
Family Court Act. So, which order you are challenging here?
I am not challenging the order, my lord. I am challenging the my lord, proceeding of the.
Here it is mentioned as order. In this provision, you see,
Okay.
legality or propriety of the order
Order.
not being an interlocutory order, and as to the regularity of such proceeding.
Yes, my lord. So, I am I am challenging the proceeding, my lord. At this stage, my lord, notice may go, my lord.
So what wrong with that proceeding pending before the family court?
Lordship, earlier, my lord, he already taken that plea, my lord. He divorced me, my lord, and this time also, my lord, he filed this case, my lord.
Whether earlier divorce was granted?
No, my lord,
Hmm.
there is no divorce, my lord.
Hmm. Where is that proceeding? Here,
Lordship,
page number
page 75, my lord.
75.
Yes, my lord.
No, earlier, in which proceeding earlier he has taken such a plea?
Lordship, in before the High Court, my lord, he filed one criminal revision petition, page 47, my lord. This honorable court, my lord, dismissed this petition, my lord. And
Pardon?
if he choose to file this divorce petition again, my lord.
No, this was a maintenance proceeding.
Yes, my lord. In that proceeding, my lord, he was taken plea that he already divorced me, my lord.
No, whether he has instituted any proceeding for dissolution of the marriage
No, my lord.
before
without any-
filing the present petition before the family court.
This is the first time he
Then where is the bar? Where is the bar in filing a case for dissolution of the marriage?
there is no bar, my lord.
Then-
He taken the false plea, my lord.
Pardon?
Regarding
Pardon?
he taken the false plea regarding
False
divorce.
plea, you go and file an application there before the family court that he falsely instituted this present proceeding. I am giving you option to withdraw this petition, otherwise I will dismiss this petition with cost. Whatever option you like to exercise, you can exercise.
Lordship, one day maybe accommodate, my lord. Engaged counsel will appear, my lord. I am not the engaged counsel, my lord. Engaged
Then
counsel.
why you are arguing the matter?
Lordship, he instructed me to.
On instruction.
Yes, no.
List the matter tomorrow for further consideration.
Lordship, on next Monday, my lord.
No.
Item 3. Most lord. Lordship, on what days day, maybe?
No, no.
Item 3. Most lord.
None appears for the petitioner on call. Perusal of the order dated 19/12/2025 indicates that the engaged counsel has already withdrawn his wakalatnama. Accordingly, it is provided that resolution notice to the petitioner and list the matter after 4 weeks.
Item 4.
My lord, in this case, my lord, the plaintiff filed the suit and defendant contested. Thereafter, evidence everything was over. When the case was at the judgment stage, then the defendant number one filed application, serving copy to the other defendants, without serving to the plaintiff, with prayer for withdraw with liberty. That was granted. Liberty was granted. Page 47, kindly see the order. I am only against the liberty part, because once the suit was contested and evidence was laid by both the parties, when the judgment is yet to be delivered, then this order has been passed.
So is there any bar in granting liberty?
With respect to liberty, because since
No,
formal,
Mr.
there is no formal, it was not mentioned that there was a formal defect in the suit, my lord.
Hmm.
If there be any formal
No,
defect,
no.
then only withdrawal can be
No, no,
allowed.
in that case, you have to challenge the entire order, not part, not in part.
Only with liberty part.
No, no. You have to
I
challenge
have
the
challenged the order, entire order.
entire order.
Entire order. I have challenged entire order, but so far is with respect to this petition which has been filed by the plaintiff,
Hmm.
that too without serving copy to the main defendant who are contesting, that is the petitioner herein.
Hmm.
Serving copy to the pro forma and withdraw the case. That too, this the honorable court allowed the petition withdraw with liberty.
No, no. Whether opportunity was afforded to you to raise any objection? in-
No. That is why I am filing on the very first day when application has been filed. That I have pleaded also in this petition. Paragraph 4 I have stated, my lord, and paragraph 5. Paragraph 5, that petitioner back to state, your lordships back to state that she being the principal defendant number one, the petitioner, in the said title suit, the respondent ought to have been served copy of so and so, but respondent did not furnish any copy of the said petition so and so to the engaged advocate of the petitioner, which preceded sine qua non before obtaining any order from the learned trial court before court below, and the learned court never given any opportunity of filing objection. Paragraph 5.
You see the order? Also heard learned counsel for the defendant who submits that he has no objection if the petition is allowed, after directing the plaintiff to pay reasonable amount of cost for the convenience suffered by the defendant.
My lord, I am the defendant number one, my lord. I am contesting. Notice has been not served to defendant number one. That specific statement I have given in paragraph 5. Other
No.
defendant, they have been served. They have served to other defendant, and in collision with the other defendant, the suit has been withdrawn. That was the averment made in this petition also, my lord.
How many defendants are there?
There are, my lord, plaint I have annexed, my lord,
at page annexure 1, my lord. Defendants, I am Anwar Begum Barbia. There are as many as 16, 12 is the main defendant, 1 to 12, and 16, 13 to 18 is the pro forma defendant.
Whether all the defendants have different counsel?
Yes, yes. I have, this petitioner has different counsel, other defendants has different counsel, except pro forma defendant. So since the matter has been withdrawn, my lord, at this stage, notice may be issued and record may be called for. It will be clear, my lord. Because question of stay, all these things does not arise at this stage. Since plaintiff suit has been withdrawn with liberty, so the case is not pending till now. At this stage, notice may be issued and record of that disposal suit may be called for, my lord.
Okay. Or Mr. S.K. Ghosh, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with section 115 and 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 3/9/2022 passed by the learned Munship number 1 Hailakandi entitled suit number 76 of 2020. It is to be noted here that by impugn order dated 3/9/2022, the learned trial court has allowed the petition number 526 of 2001 filed by the respondent under order 23 rule 1(3) of the Code of Civil Procedure and allowed the plaintiff to withdraw the suit with liberty to file a fresh one by imposing a cost of rupees 8,000. Mr. Whose learned counsel for the petitioner submits that the petitioner was the defendant number 1 in the title suit number 11 of 2011. And while disposing of while allowing withdrawal of the suit, the defendant number 1 was never furnished a copy of the petition filed by the plaintiff. Under Order 23, Rule 1, which is 3 of the CPC, and he has not been afforded an opportunity to file any objection to the said petition. And under such circumstances, the impugn order dated 3/9/2022, passed by the learned Munship number 1 Hailakandi, is illegal and arbitrary, and on such count the same warrant interference of this court. The submission of Mr. Ghosh needs further consideration. At this stage, notice be issued to the respondents returnable in 4 weeks, step by speed post and also by usual process within a week from today. Rest shall call for the record from the learned trial court based on matter after 4 weeks.
My lord, I have filed under 115. Not under 227, 115. There was delay was condoned, then it has come.
You see the first title?
220, both I have mentioned.
material. It will allow me to show some latest judgment, my lord.
You got the judgment?
Well, this is the 2022, my lord.
Hmm.
Oh. I think cover, my lord. It says all, generally all amendments should be allowed, except some. Aniruddha Bush, JB, Prabhudeval observed. It is Life Insurance Corporation of India Limited. There are 70 in clear.
Era?
70 of the first judgment.
Where is the petition? Filed before the trial court?
Yes, this petition is, my lord, impin order is page 14, and the said petition is, she will find petition. My lord, page 72.
You say the trial court has observed that the amendment sought shall give rise to a new cause of action,
Yes, ma'am.
and therefore the trial court has rejected your application.
So, my lord,
So
whatever the.
there was a pair for change of the schedule also.
Yes, my lord, because schedule changes, my lord, while the case is going on, my lord, some new, my lord, cause of action arise. Because at that period of time, my lord, the defendant, my lord, the opposite party defendant, my lord, they
No,
constructed house.
Mr. Uddin, you tell me
Yes.
if at this stage the schedule is changed, then would it not change the nature and character of the suit?
No, my lord, it will not change because earlier in the same schedule, it is within that property, my lord, that suit land, there is, my lord, when the case is going on, another, my lord, the cause of action. I have pleaded, my lord. Lordship will find in para, my lord. That my lord, this third schedule, about third schedule, my lord, in it will find lordship of page 83, my lord. Sorry, my lord, not 83. My lord.
Mr. Uddin, let notice go at this stage.
Notice. Yes, my lord. Because, my lord, as per, my lord, I have gone through all this petition, my lord. It is only within the suit land, my lord. Some new cause of action arose, my lord, because of, my lord, that intervention of the defendant, my lord.
And what is this? The suit is pending now?
It is at, my lord, at only necessary order. Because there is no issue frame, my lord. Not still to frame issue, my lord, next stage. I have filed the title suit, my lord. They have filed the written statement along with my counter claim, my lord. Thereafter, I filed written statement against the counter claim. And in the meantime, I have filed this petition. After filing of the written statement, I came to know some new facts, my lord. And during that period also, there is a, my lord, inquiry by the advocate, my lord, commission. So definitely some new course of action arose. It will not change the nature of matter anyway.
No, already there is an observation made by the trial court.
Right.
Therefore, let notice go, let the other side appear. We will
Right.
hear both the parties.
Yes. In the
Therefore, we
meantime, my
consider
lord,
it
my suit will be stated.
heard Mr. Uddin, learned counsel for the petitioner. Pursuant to order dated 11/2/2026, Mr. Uddin has produced one decision of the Honorable Supreme Court in the case of Life Insurance Corporation of India versus Sanjit Builders Private Limited and another, reported in 2022-0 Supreme, SC, page number 864. And also another decision of Honorable Supreme Court in the case of Dinesh Goel alias Papu versus Suman Nagoral, between Bindal and others, reported in 2024-0 Supreme, SC, page number 816. It is to be noted here that in this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the order dated 15/12/2025, passed by the learned civil judge senior division Sribhumi in Miss case number 81 of 2025. In petition number 567/4 dated 18/12/2024 under Order 6, Rule 17, read with Section 151 of the CPC, arising out of title suit number 32 of 2023. Notably, by the impugn order dated 15/12/2024, the learned civil judge senior division Sribhumi has dismissed the petition filed by the petitioner for amendment of the plaint on the ground that there is a long gap between filing of the written statement and filing of the prayer for amendment of the plaint, and further observing that the amendment sought shall give rise to a new cause of action. Peruse the petition and the documents placed on record, and also peruse the impugn order dated 15/12/2025, and also gone through the decisions produced before the court today by Mr. Uddin, learned counsel for the petitioner. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Is there any interim period here?
Yes, madam. In the meantime, my title suit may be stayed. My title suit is pending, my lord. That may be stayed. Otherwise, my lord, if this written, my lord, amendment.
Pending further consideration, title suit number so and so, filed by the present petitioner, stands state till a returnable date.
Number 6.
The contempt petition, Millets. The order is at page 15 of this honorable court, which we have said is violated by the respondents. What we'll see at page 51, there is a status quo order by this honorable court. Millets.
Okay, let notice go.
Notice.
Heard, Mr. Your
A.
name,
Gautam Millets. A. Gautam Millets.
D.
A. Gautam Millets.
Okay. Learned counsel for the petitioner. This petition under section 12, read with section 2, which is bracket B of the Contempt of Court Act 1971, is preferred by the petitioner for initiating contempt proceeding against the respondent contemptor for willful disobedience of the order dated 26/11/2025, passed by the learned The passed by a coordinate bench of this court in FAO number 75 of 2025. In connection with the order dated 6/11/2025 passed in Mizze case number 5852 of 2025. Arising out of title suit number 505 of 2023 by the learned civil judge senior division number 1 Kamrup Ahmed Gauhati. Let notice be issued to the respondent, stroke contemnors, returnable in 4 weeks, that be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Grateful.
36.
May I please, Lordship. Here in this case, my lord, the suit was already, my lord, awaited, my lord, for the death of the defendant number 8, Lordship. My lord, this says, Lordship, the plaintiff submitted my application for amendment, Lordship, with a proposal to some, my lord, and my lord, introduce my lord, fresh cause of action, Lordship. My lord, the cause of action stated in the, my lord, plaint was, my lord, 30/4/2023. My lord. My lord, against many as my lord 13 defendants, Lordship. Now, in the amendment application saying that during pendency of the my lord suit, my lord, the defendant numbers 6 to 8, Lordship, entered into the land, my lord, and dispossessed them, Lordship. This is fresh cause of action against my lord only respondent number 6 to 8. My lord, this was allowed, Lordship. Kindly see the my lord at page impugned order is at page 43, Lordship. We raised,
Paragraph number of the
Ma-
order.
Lordship. My lord, this paragraph, my lord, at at page 45, Lordship, on such perusal, Lordship. Fact, before that, my lord, facts have been stated, Lordship. Page 45, on such perusal of it is transpired that
No, whether that fresh cause of action cannot be adjudicated in the present title suit.
my lord, facts, my lord, this is the introduction of the new, my lord, fact, Lordship. Already, my lord, prayer for eviction against all the respondents, my lord, we are made in the plaint, Lordship. My lord, thereafter, my lord, a part, my lord, they are so new cause, Lordship. Another part of the, my lord, suit land has been, my lord, transferred, Lordship. This is new, fresh cause of action. Fresh suit is, my lord, maintainable, Lordship. Now, that has been, my lord, introduced in this same plaint, Lordship. So, this honorable, the Honorable Supreme Court, my lord, in many cases, Lordship, it is the, my lord, cause of action cannot be changed, Lordship. This is the fresh suit, Lordship, against only defendant numbers 6 to 8, Lordship.
You saw the decision?
My lord, judgments, I have judgments, Lordship. First one is, my lord, kindly see paragraph 37 and 39, Lordship. 39, my lord, it will do, Lordship. Paragraph 39 before the last page, Lordship. May I read, Lordship? When the plaintiff cannot get the relief sought to be added as a result of the amendment on the facts mentioned in the plaint, originally it is clear that the cause of action for a decree for rupees so and so is different from the cause of action on which the suit for declaration was found. For that suit is originally instituted, the plaintiff had merely to prove the terms of the contract between the parties and to show that his interpretation of these terms was the correct one. and that interpretation justified the declaration sought. A suit based on one cause of action cannot be allowed to be changed into suit based on another cause of action, Lordship. My lord, their prayer is, my lord, in the plain, Lordship, to introduce, my lord,
No,
that
no,
different
that's
cause
right,
of
but
action.
during the pendency of the suit land was the plaintiff was dispossessed.
Lordship, my lord, is from another part, Lordship.
Hmm.
My lord, my
No,
lord,
no, whether that part is not the part of the suit land.
my lord, suit land, the prayer against which was made, Lordship, that was not part, Lordship, of the suit land, Lordship. My lord, suit land, 3 kathas was already, my lord, as per my lord, plain, Lordship, was dispossessed, my lord, in my lord, on the, before my lord, filing of the suit, Lordship. Now, after filing of the suit, my lord, another part was, my lord, dispossessed. This is the fresh cause of action against only defendant number 6, 7, and 8, Lordship, not against others, Lordship. So this is a fresh suit lies, Lordship.
No, no, schedule of the property is the same.
Schedule of the property of one schedule is same, Lordship. Schedule, my lord, in my humble submission, schedule is no matter what, only, my lord, the whether the that is filed, that was filed after filing of the suit or not. After filing of the suit, Lordship, in the plain cause of action is distinctly stated, Lordship, this is the cause of action. After filing of the suit, this is different cause of action. My lord, how this?
No, no, my question is whether the schedule of the
D1 schedule, Lordship.
are same.
D1 schedule. D1 schedule, total land is, my lord, 2 kathas, 3 kathas, my lord, something, Lordship. I'm sorry, Lordship. 2 bighas, 1 katha, 5 lassa in B1 schedule, Lordship. And they were allegedly, my lord, evicted 3 katha out of this 2 bigha, Lordship, before filing of the suit, Lordship. But after filing of the institution of the suit, Lordship, it is stated the entire plot of B1 schedule land has been dispossessed, Lordship.
But that land is also a land of the schedule mentioned in the plain.
That was the schedule, Lordship, part of the schedule land, Lordship.
Okay.
Now, kindly see the cause of action stated specific,
No,
Lordship, in paragraph.
Mr. Ahmed, you see, the second decision you have relied upon.
My lord, this is a second decision, Lordship. This is recently one, Lordship. Before the last page, Lordship, Roman 10, Lordship. Before the last page, Roman 10, Lordship. Where the amendment changes the nature of the suit or cause of action as to set up entirely new case foreign to the case set up in the plain, the amendment must be disallowed. This is one point, Lordship. Another point, my lord, the suit was already, my lord, abated, Lordship. My lord, whether that suit can be further proceeded, Lordship. I have stated in paragraph 8 of the, my lord, petition, Lordship. My lord, paragraph 8 of the petition, Lordship, at
How it is abated?
My lord, the respondent number 8, my lord, expired. Respondent number 8 expired on 16/3/2025. It was informed to the court on 23/2025. Now, without, my lord, substitution, Lordship, against whom, my lord, the prayer is made, my lord, joint possession of the, against the respondents, the defendants, my lord. It means, my lord, joint possession is there, Lordship.
Whether you inform the trial court that
Yes, Lord, in the paragraph
defendant number
8, it is stated
suffered
on
demise?
23/3/2025, it was informed, Lordship. In my humble submission, my lord, once, my lord, suit is abated, Lordship, it cannot be proceeded, but no application is, my lord, maintainable in this case, Lordship.
Well, let notice go at this instance.
Lordship.
Heard, Mr. Ahmed, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India read with section 115 of the Code of Civil Procedure. The petitioner has challenged the order dated 6/1/2025 in Music case number 322 stroke 2024 arising out of TS number 16 of 2024. Passed by the learned civil judge, Senior Division, Borpeta. It is to be noted here that by the impugn order dated so and so. The learned civil judge, Senior Division, Borpeta, has allowed the application filed by the plaintiff for amendment of the plaint. Mr. Ahmed, learned counsel for the petitioner, submits that the impugned order is challenged on 2 counts. Firstly, Mr. Ahmed submits, Ahmed referring to a decision of Honorable Supreme Court in Life Insurance Corporation of India versus Sanjeev Builders Private Limited and another, reported in 2022 Supreme (SC) page number 864, especially to clause number 10 of para number 70, submits that when amendment changes the nature of the suit or the cause of action so as to set up an entirely new case, foreign to the case set up in the plaint, the amendment must be disallowed. And where, however, the amendment sought is only with respect to the relief in the plaint and is predicted on facts which are already pleaded in the plaint, ordinarily the amendment is required to be allowed. And secondly, Mr. Ahmed pointed out that one of the defendant named,
Yes,
what is the name?
Defendant number, my lord, 8, lordship.
One of the defendant, namely defendant, no, that the defendant number 8 of the suit, namely,
Lordship.
suffered demise on 16/3/2025, and as such, the suit stands abated, and without impleading the legal heirs of the defendant number 8, the court ought not to have proceeded with the matter, and under such circumstances, Mr. Ahmed submits that the impugned order requires interference of this court. The submission of Mr. Ahmed needs further consideration that this is notice be issued to the respondents, returnable in 4 weeks, step by registered post with ADN, no, step by speed post with ADN, also by usual process within a week from today. List after 4 weeks. Till returnable date, further proceeding of the title suit number 16 of 2024 stands state. List after 4 weeks.
The name of the respondent number 8 is Abdul Mannan, lordship.
Abdul Mannan.
Lordship.
Okay, you incorporated.
Obliged, lordship.
I'm praying for tomorrow also for listening the results. We have already informed others.
No, on 13th also you have taken
Yes,
adjournment.
because certain personal, I will say, okay, that's why we are seeking for certain sort of accommodation also.
Wednesday?
Wednesday and Thursday will be difficult for us. That was tomorrow.
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 Oh, Kali only. Then Friday, next Friday.
They have given an undertaking that they have not construct in the property.
That's why we have the sought for listing tomorrow last. So they don't.
Tomorrow is hearing day. If we take the motion matters, we will not be able to hear the other matters. Friday then.
Right.
Heard Mr. Cabral, learned counsel for the petitioner. And Mr. Bhakhtiar, learned counsel for the respondents. Mr. Bhakhtiar, press for listing the matter tomorrow. As Mr. N. Along, learned counsel. Conducting counsel for the respondent has some difficulties today. Since tomorrow is a hearing day, it is provided that recess shall list the matter on Friday.
Item 38.
Creator would be hard. Career distance research.
May I please, Lord? Lord, kindly see the impugned order is 36. Lordship, my impugned petition, Lordship, has been dismissed, Lordship, by the learned court below in a title suit, Lordship, on the ground that, Lordship, in a specific performance of contract, only two parties are required. And in a specific performance of contract cannot be converted to a title dispute case. Accordingly, my case has been dismissed.
What wrong with the order?
Here in this case, fact is also important, Lordship. The defendant in the title
No,
suit,
if
Lordship,
according to you, in a suit for specific performance of the contract,
yes, sir.
there shall be only two parties.
This is the observation by the learned court.
Yes, what wrong with that?
Lordship, when Lordship, a third party, there he has been Lordship in a position to establish his right and title and interest over the suit land, Lordship, then he may be implicated. Otherwise, he will be prejudiced. Here in this case is that, Lordship, petitioners and the defendants are own brothers, Lordship.
Where is the impugned order?
Page 36. Lordship, I am, Lordship, kindly allow me to submit on facts, Lordship. The petitioners and the defendant of the title suit are own brothers, Lordship. And the defendant, by virtue of
First of Mr. Sarkar,
Lordship,
admittedly, the suit is for specific performance of the contract.
Lordship,
And in the case of specific performance of the contract, there are only two parties, plaintiff and the defendant.
yes, Lordship.
So how can the court allow your application for implement?
Lordship, for his, Lordship, kindly allow me for bear with me, Lordship, for the fact for a moment, Lordship. Petitioners and the defendants are own brother, Lordship. The defendant, what happened?
Maybe.
Lordship, kindly, Lordship, he forced the gift deed shown to have been executed by our fathers, Lordship. And by virtue of force, gift deed, Lordship, he mutated
No,
his name
if-
and Lordship.
If your right is violated by your own brother,
Yes, Lordship.
you file a separate suit.
We have also already filed, Lordship,
Then-
separate suit, and which is also pending, Lordship.
Then
And what happened, Lordship? The suit, the title suit was filed on 25/20/25. And Lordship, within 1 week, Lordship, kindly see.
no, we are not concerned with that title suit now.
Now, Lordship, within 1 week they have
You-
filed, Lordship, compromise
No.
petition, Lordship.
Mr. Sorkar,
Lordship.
you tell me on what count this impugned order suffers from any infirmity or illegality requiring interference of this court?
Lordship, if the petitioners are not allowed to implement the case, Lordship.
No, you show me any of the citation
Yes, Lord.
or decision of the Supreme Court where a third party can be implicated
Yes.
in a suit for specific performance of the contract.
This judgment is passed, Lordship, in the light of also discussing the some important Supreme Court judgment, Lordship. Kindly see page para 26 and 27. And para 26 and 27. 27 is most important, Lordship.
Mm. Mm. Oh, here in paragraph number 28, it is stated that it is a judicial discretion.
Yes, Lordship. That's also
If the trial court has exercised jurisdiction in a particular way, can this court interfere with the same? So the ratio laid down in the postory,
yes, Lordship.
in the case of
Yeah,
postory,
Lordship, this is the
that was a three judgments decision.
yes, Lordship. But Lordship, in the light of those judgments, Lordship, this judgment has been passed, Lordship. This is the recent judgment, Lordship. Here in this case, Lordship, initially titles in trial court allowed the impleachment petition, High Court rejected the same, and that was challenged before the Supreme Court. And this observation is para 32, 33, and 34. This is the 25 judgment, Lordship. 32, 33, and 34.
The problem is that if the trial court has exercised its discretion and taken a particular view in dealing with a petition under Article 227, this court cannot substitute its own view.
Yeah, look, this is the, your Lordship, right? This is the discretionary power of the trial court. But here in this process, also Supreme Court states that, Lordship, if a third party can show a fair semblance of title of interest, he can file an application for impeachment.
No, that's all right, but you have already filed one title suit.
We have already filed, Lordship.
We have to
same
see.
pending. And Lordship, kindly see how they have pre-planned, Lordship, the defendant and plaintiff. Within 7 days, they have filed compromise petition, Lordship. And tomorrow is fixed for, Lordship, for hearing on compromise petition. Lordship, compromise petition, we have annexed, Lordship. Kindly see page 38, Lordship.
Within 7
No.
days, Lordship, compromise petition has been filed
Hmm.
after filing the title suit, Lordship.
Hmm.
Page 38. Annexure
So is
5.
there any bar in filing compromise petition within 7
No,
days?
so there is no bar, but
Then-
Lordship, within 7 days, they have compromised and the sale deed agreement was executed in the year 24. And after filing Lordship title suit, they immediately settled the matter. Why they are in hurry, Lordship? So Lordship, kindly allow us to include in the title suit, and Lordship, we will establish our claim, Lordship, there.
You have already
Yes,
filed
ask.
title, so you go and pursue that matter.
Lordship, the by virtue of fact, if the defendant sought to sell the plot of land, Lordship, our father's property, Lordship. So our
That will
rights,
be adjudicated in the trial suit, okay, title suit. Anyway, we'll pass the order. We'll again go through the decision. Pass the order.
Authorised.
May I please, your Lordship? My lord, a manuscript was filed before the landed Munshif at Kamrup Petro. Thereafter, claiming rupees 9 lakh 98, that is almost 10 lakhs from the petitioners. Now, due to pecuniary jurisdiction, my lord, the case was transferred to the landed district judge for taking further action. Then the landed district judge transferred the suit to the landed civil judge number 1 at Kamrup Metro. In the long run, judgment was delivered ex parte, that is page 9, madam. We are we were the defendant in that manuscript, my lord. We
And now
filed,
you are the judgment debtor.
my lord,
You are
the
the
judgment
judgment
is
debtor
page
now.
9. The thing is this, my lord. Now, after the judgment was delivered by the landed civil judge senior division, case was transferred to Bongaigaon because respondent resides at Bongaigaon for execution of the decree. Then the landed the executing court, that is the landed civil judge at Bongaigaon, passed order. Lordship, kindly see page 25. Regarding decree, we have nothing to say at present because our decree has been passed. We appeared, thereafter did not appear because of transfer of the court, but that was not properly informed. Notice was not issued. So, however, as we have filed WS, so learned Civil Judge Senior Division Bongaigaon passed order, that is page 25, asking the decree holder to furnish particulars of the movable and immovable properties for execution of the decree. Page 25 bottom. Then later on, case was fixed on 17/1/26. On that day, the decree holder that means present respondent, was asked to deposit money in police head so that in the treasury, so that the execution may be carried out through the help of police by attaching all the properties. Then we filed a petition that we will file review petition before the landed trial court that the order was passed as ex parte basis. But the landed civil judge, that is the executing court, did not pass any order on our petition. That is page 27, my lord. Page 27, no effective order is passed on that. Only it is said, so kindly see page 26, my lord. Second para. I have also perused the petition number so filed by the judgment debtor number 1, stating that he intends to file a petition under section 47 of the CPC request, allowing him a time to file the same. Now the judgment debtor is at liberty to file any petition he wants, which will be anyway disposed as per its merit. So that was his observation that he is at liberty to file any petition. But
Yes.
as the judgment was delivered by the learned civil judge senior division at Kamrup, it has to be filed here. Now, this petition was in that manner disposed of. And the last order, Honorable Court passed order, that is page 27. Decree holder is represented through his engaged counsel. Now, perusal of the case record goes to show that earlier the civil Nazir had reported that police security will be required to carry out the execution of the decree in this case. Hence, the decree holder is directed to take steps to issue notice to the senior superintendent of police, Bongaigaon, asking him to submit an estimate for the cost of the to be incurred for police assistance in carrying out the execution process of this case. He is also to inform the convenient that when the said police assistance can be provided to carry out the said execution process. Last para, fixing 17.2, that is tomorrow, my lord. So in this manner, my lord, we have come before the Honorable Court. We are ready to pay the amount, though in our estimate the amount was 7 lakhs, they say it is almost 10 lakhs. Now more than 10 lakhs including cost and interest. So we will pay the amount. We simply has filed this petition, kindly grant us 10 equal installments to pay the amount. In this figure we have several citations.
No, you filed that application before the executing court.
But in this case, High Court has granted installments.
Maybe.
High Court has granted. Kindly see this order, para 18, 19, and 20. So if in 10 equal installments, it will be more than 1 lakh. Now business is very much down, my lord. Businessmen are suffering badly. So they are businessmen. The petitioners are businessmen. So kindly
And,
keep para
decree holder
18,
is
19, and 20. Can you see?
decree holder is not suffering for non-payment of the such a big amount.
Big amount means more than 10 lakhs, of course. Now I am ready to pay. That it was also the similar case. Kindly see page 18 onwards.
Mr.
We have
Mahmood, you have filed this petition under Article 227 and under Section 115 of the Code of Civil Procedure. Whether in exercising this revisional jurisdiction, this court can permit you to make payment of the decretal amount in installment.
But this is because we are not so much on deep disputes. So on a simple disputes, we may kindly be allowed.
No.
Inherent power of the court may be exercised as it was exercised in this case. Kindly say para 18, 19, and 20. Para 18 I am reading. We have gone through the decisions cited above and the aforesaid provision of CPC, and it appears to us that in those reported cases, the question of recovery of decretal amount arose out of final decree in a mortgage suit. But in the present case, the decree and not against a final decree. Moreover, the provision of order 20 rule 11 of CPC dealt with a money suit, simply cited allowing installments wise payment. But the aforesaid
Mr.
provision-
Mahmood, you see this judgment was passed in the year, which year? 2001.
Yes.
There is a recent judgment of Supreme Court where it is directed that within a period of 6 months, decree has to be executed.
That I know.
Then?
But my lord, that means we are not against the decree. That is why, my lord, I have simply prayed that we are ready to pay, but due to peculiar situations, our poverty and business losses, I have limited resources. Even if the amount, the utensils or the materials of the shops are attached, even then they will not get entire money.
That is a different aspect.
The rest they would have to take from another time. So in my prayer is that only
this we are dismissing this petition, granting you liberty to approach the trial court by approaching by filing appropriate petition.
That I think, my lord, instead of dismissing,
You go and file an application
it give again liberty.
for
to
allowing
file-
you to,
Allowing equal in monthly installments. So that
you go and file an application there.
now we will file, definitely we will file petition. But instead of dismissal, Lord, it may carry a wrong message. So the matter is disposed with liberty granting to the petitioners to file a
Then
petition.
withdraw it.
And then Lordship would pass that order. Yes. We only want relief because his financial condition is extremely bad.
Okay, we will pass that order.
Yes.
Yes.
And
next.
learned court will sympathetically
Not
consider.
sympathetically, in accordance with law.
In accordance with law, it will again perhaps we would be compelled
No,
to
no.
come before your lordship.
No, in accordance with law.
About 13 matters for orders.
You see, the judgment was passed in the year 2024.
Yes.
What is the period of limitation for filing review petition?
That is 30 days.
30 days. How many 30 days over since the date
No,
of judgment?
the reasons were there. Cases have been transferred from one court to another court. So these are the reasons. So even then, now we are ready. We do not want to waste time, provided some simplicity
Okay.
may be ordered, obliged.
Item 13 for orders.
The amount has been sanctioned, my lord.
Sanction.
Yes.
You have seen this?
My lord, that's he already given the sanction. So my lord, 2 weeks time may be granted. In the meantime, I will take instruction whether they have received or not. Not yet received, as per my instruction is concerned.
No, since the amount has been sanctioned, they will be receiving it.
Yes.
When it will be completed?
Sanction is long back in 10/2, but not yet received. As per my instruction is today morning, my lord. Let the
It
matter
was sanctioned on
10/2, my lord. 10/2, 2026.
10.
Yes.
You may get it within a week, perhaps. We can close this matter then.
My lord, let the matter be taken up after 1 week, my lord. I will take instruction. If they receive, then I will
No.
do this also.
After sanction of the amount, there is no question of not releasing it in your favor.
Well, just after 1 week, my lord, I will
Okay.
take instruction.
Heard Mr. Islam, learned counsel for the petitioner, and also heard Mr. Khatunier, learned counsel for the contender, producing a letter of the Deputy Secretary to the Government of Assam, dated 10/2/2026, addressed to the AG Assam. Mr. Khatunier submits that the amount which the petitioners are entitled to has already been sanctioned and will be deposited in their accounts shortly. However, Mr. Islam, learned counsel for the petitioner, submits that the matter will be listed after 1 week. They are allowed recess and list the matter after 1 week. The letter produced before the court today shall be marked as Annex A and be taken to the record. After 1 week, on next Monday.
Of the press, 25th.
Monday, okay.
17.
May I please your lordships? As per office to lordship, service is also complete as showed. And Lajima court also shows lordships. And last order lordship also shows 17/10/25, notice number 46 is returned back after due service. Then again we take also service of other respondents. That is also shows service completed as per office note shows basis of.
So service completed.
Service completed.
Record received. Matter is ready for hearing.
Yes, lordships.
Heard Mr. Borbuya, learned counsel for the appellant, and Madam, your good name, please? R. Setri for respondent number
1, 3, and 5.
1, 2, 3, and 5. Mr. Borbuya, learned counsel for the appellant, referring to the order referring to the office note dated 7/1/2026 submits that service in respect of all the respondents have been completed and the record from the learned trial court and also from the first appellate court has been received and the matter is ready for hearing and the same may be listed for hearing. Accordingly, it is provided that recites shall list the matter for hearing in usual course on a date to be fixed by the registry.
Like,
Respondent number 123.
123.
Petitioner is absent. None appears for the petitioner on call. How about Mr. Das?
K. Das, Lordship.
K. Das, learned counsel for the respondent number 123 present. It appears that on 26/5/2025 also the petitioner remained absent without any step. Today also the petitioner remained absent. In view of above, it is provided that rest shall list the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. A list on COVID. Fix it. 27.
Item 19.
Lordship, paper publication was made against the respondents. So we have submitted the paper publication. Plus order in the IA number 822 of 23. We submitted the affidavit also.
(822) is for implement.
No, Lordship, 822 for Lordship Section 5 application. 1 day delay is there in filing the revision. So then when notice was issued, they didn't appear. So this is a paper publication was ordered. We have taken the paper publication.
Delay was only for 1 day.
Only 1 day.
Why 1 day was delay?
Lordships are not misguided. Because in obtaining certified copy, calculation is wrongly been made.
Heard Mr. R.K. Bhuya, learned counsel for the petitioner. No, for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 1 day in filing connected civil revision petition against the judgment and order dated 13/11/2015 passed by the learned Munship number 2 Kamrup M in title suit number 465 of 2010. Mr. Bhuya, learned counsel for the applicant submits that the applicant has effected service of notice upon the opposite parties by way of a paper publication and an affidavit to that effect enclosing the concerned newspapers in which the notice was published is also enclosed. Further, Mr. Bhuya submits that there was delay of only 1 day and while calculating the delay in there's a wrong calculation in respect of
certified copies.
Okay. That while obtaining the certified copy, there was a wrong calculation of the date. the wrong calculation of the days. And as such, the concern, the connected civil revision petition could not be filed in time, and the delay is not intentional and rather circumstantial, and under such circumstances, Mr. Bhuya contended to condone the delay of 1 day and to register the CRP. Accordingly, having heard the submission of learned counsel for the applicant, this court has carefully gone through the application and the documents placed on record, and also the affidavit filed in respect of effecting service of notice upon the opposite parties. It appears that even after service of notice upon the opposite parties by substituted mode, they have failed to turn up. And further, from the submission, as well as from the statement and environment made in the application, it appears that the delay of 1 day is sufficiently explained. And accordingly, the same stands condoned. In terms of above, this IA stands disposed of. In view of the order passed in the IA, now the registry will register the CRP and list the same before the court as soon as practicable.
Item 20.
That's right. It's better, my lord. Steps was taken, registered post as well as usual process. But the my lord, as per office note, no report or etiquette has been received. So my lord, the petitioner may be allowed to take thus the steps, my lord. It's a matrimonial dispute. So intentionally they are avoiding service. Thus the service may be allowed.
Heard Mr. Nath, learned counsel for the applicant. And learned counsel for the petitioner. Office note dated 19/6/2025 indicates that service of notice. The service report in respect of the notice issued to the respondents have not yet been received. Mr. Nath submits that he may be allowed to, no, Mr. Nath submits that the petitioner may be allowed to effect service of notice upon the respondent by testimony. They are allowed. After effecting service upon the respondent by testimony, the petitioner shall file an affidavit to that effect before this court. List the matter of 4 weeks or 2 weeks.
2 weeks, man.
2 weeks.
Obliged.
21.
May please your lordship. As per last office note 9-1 lordship, service has already completed and lordship LCR also received. So let the matter come up for final hearing, lordship.
Heard Ms. P. Bhattacharya, learned counsel for the appellant. But
Service completed, lordship. Earlier also in delay condonation petition also that was completed. Again, I have taken steps in the main appeal. That is also 9-1.
Ms.
lordship.
Bhattacharya submits that service in respect of the respondents completed and the record of the title appeal number 14 of 2014 and the title suit number 424 of 2010 have been received from the learned courts below, and the matter is ready for hearing. Accordingly, it is provided that registrar shall list the matter for hearing in usual course on a date to be fixed by the registrar.
Obliged.
Item 22.
Yeah, please, your lordship. As per order dated 16/5/2025 and affidavit in opposition was filed by the respondent party. However, lordship, we haven't received it yet.
No, I will give him another copy.
Okay. Heard, Mr.
JP Bosho.
J.P. Boyce, learned counsel for the petitioner, and Mr. B. Chakraborty, learned counsel for the sole respondent. So Boyce submits that the respondents hearing have filed one objection petition, and copy of the same has not been furnished to him. Mr. Chakraborty undertakes to furnish a copy of the same during the course of the day. This is the matter. After a week,
Objection.
Wait, please, check.
yes,
My lord, make I.
Yes, His Lordship. I would like to pray for the adjournment of this matter.
yes,
For adjournment of this matter, I would like to pray for this.
My lord, may kindly say order dated 1/10/24
Hmm.
regarding interim manner. Since they are taking adjournment, my lord, interim may be extended, man. Interim may be allowed.
okay. Heard Mr. Colita, learned counsel for the petitioner, and also heard Miss
D.R. Ahmed.
learned counsel for the respondent. The learned counsel for the respondent is for an adjournment. And accordingly, it is provided that recessal is the matter after 1 week.
Any date. Much obliged.
Sorted Kabir, so interim period there. 25th. Interim period will be considered on that day.
Lordship, there is a observation in 1/10/24, my lord.
Yes, I have seen it.
That may be, I'm praying for an interim, my lord, if Lordship
Maybe
allows me.
without hearing the other side.
May I please, Your Lordship, my lord, hearing this appeal, my lord, there is 709 days of delay in filing the second appeal, my lord.
Please, I is for what?
My lord, 709 days, my lord.
Oh, condemnation of delay.
My lord, condemnation of delay.
Okay.
At para 6, 7, and 8, my lord, I have explained why there is a delay, my lord.
What is the reason?
Para 6 and 7, my lord. And 8, my lord. Married, my lord.
No, you briefly tell me the reason
My lord.
which are stated in these paragraphs.
My
You
lord.
are not prepared.
My lord.
You tell me the reason.
6, 7, and 8, my lord. Because, my lord, here, initially, my lord, his father, appellant number 1's father appeared in the suit, my lord. So he has died in the year 2016, my lord. And petitioner number 1 is an ex-army man, my lord. He has to look after this, my lord. During that period, he also at his posting site outside the Assam, my lord. So he could not, in between that period, he could not, my lord, appear before the court, and so appeal was accordingly allowed, my lord. Suit was partly allowed, my lord. Subsequently, my lord, after receipt of the execution, notice of the execution, my lord, they appeared, because during this period there is a COVID also, my lord. 19 to 21, my lord, there is a COVID. Subsequently, they have received the notice, my lord, for execution case, my lord. On which, my lord,
No, Mr. Alam, why you could not file the appeal within the stipulated period? You explain it.
during this period, my lord, that's why, my lord, we could not file the statutory appeal on time.
When the judgment was pronounced.
Judgment was pronounced on, my lord.
2019.
2019, my lord.
2019. On which date?
17 August 19
17.
17/8/2019, my lord.
And when the COVID starts?
My lord,
When the
COVID starts,
COVID starts?
Period has been adjusted.
adjusted, that was adjusted, my lord.
After adjustment of that
After
period also.
adjustment, it is 709.
709.
Okay.
And interestingly, here in this appeal, my lord, specifically, my lord, merit of the appeal, because, my lord, defendant number 2 and 3 is not a party.
No, I am asking you about the reason for delay.
Yes.
That I have stated in para 7 and 8, my lord, in my condonation petition, my
No,
lord,
that-
wherein I
no,
have
what is
stated
there in
that,
the
my lord,
7 and 8?
my lord,
What is there in the 7 and 8?
7 and 8, my lord, they have, after the death of his father, appellant's father, my lord, the judgment was decreed on 17/8/2019, my lord. He
After the
was,
death. After the death of the father.
my lord, they were implemented as a party, my lord, so substituted, my lord, on
no.
9/6/2016.
You have to explain from the date of pronouncement of the judgment, not prior to death.
That's why I am coming, my lord. Thereafter, my lord, on to with effect from 2020, my lord, there is a COVID-19, my lord. So they could not. In fact, there is a restriction in movement, my lord. Thereafter, my lord, they have come. Title execution copy received the copy on, my lord, 14/12/2021, my lord. And accordingly, normally, my lord, here, my lord, what happened, my lord, after some decree was against the party, my lord, they are normally approached before the advocates of the particular lower court, my lord. And they have also accordingly approached before the that advocate, my lord, but he could not turn out to file the appeal, my lord. That's why I have also explained this. We have no allegation against the advocate, but they have approached initially with the advocate, my lord, concerned advocate. We have no objection, and in my petition also we have raised no allegation against the advocate, but initially we have, because since, my lord, they don't know about the filing of appeal and other things, my lord, so they have approached their advocate, my lord, concerned advocate, my lord. Accordingly, my lord, the advocate have kept the matter pending for another 1 year. Subsequently, they have taken the file back to the and came to Gauhati, my lord. That explanation is also given, my lord. Physically came down on 10/9/2023, my lord, and engaged the present counsel on 11/9/2023, my lord.
When the earlier advocate returned the file to you?
No experience.
Month of April, and he is subsequently prior to this 10/9/2020, prior to this, they will
No,
return
my
back the file.
specific question is when the earlier engaged counsel had returned the file to you.
That prior to 10/9/23, my lord. That 1 month prior, my lord. Immediately they have come down to Gauhati, my lord.
Prior to?
Prior to 10/9/23. And appellant again came down on 30/9/2023, and the engaged counsel prepared the appeal on 11/10/2023. So there is a delay of 709 days, my lord. That is not willful or deliberate, my lord, but due to the somehow, my lord, there is ignorance, and also the applicant number also engaged with his service matter. And as I have also stated in my condonation petition, my lord. And other members of the family, they are also condonation women, my lord.
Whether
And
any
another thing,
relief
lord,
is
that,
granted to that effect? Can you claim any concession to that effect?
my lord,
Other members of the family are pardonation ready.
my lord.
Whether the delay can be condoned on that ground?
No, my lord, I am not on that issue, but I am just submitting that.
You were submitting before the court.
because my lord, since my lord, their elder brother is looking after the entire property and other things, my lord. And he is in the Indian Army, my lord, serving in the Indian Army, my lord, during this period, my lord. So he also follow up the court cases also, my lord. That's why there is a some there is a illegality, my lord, that I am admitting, my lord. So for this, my lord, I am praying before your lordship may condone the delay with any cost, my lord. If my learned senior sir is agreed. With cost, your lordship may condone the delay, my lord. Otherwise, an malicious matter will be dismissed without hearing, my lord. Since, my lord, that issue relates to the specific relief act, and defendant number 2 and 3.
There is concurrent finding of fact.
No, my lord.
By both the
Not
court.
confirming, my lord. That first appellate trial court, my lord, partly decreed and allowed the plaintiff to return back his advance payment consideration, which was subsequently set aside by the appellate court, my lord.
What's your reason?
Yes.
In this case, your lordship, so far the explanation is concerned, these are all vague explanation, your lordship. If your lordship come to page 18, they have stated that on 14/12/2021, they got the information about the judgment of appeal. And they got the certified copy only in the February 22. So from the February 22,
You are referring to page number?
page number 9,
9. Paragraph number?
para 8.
Para 8.
Thereafter, the appellant have received summons of title execution number 29/2021 only in the month of December 2021 and contracted with another advocate at Silchar Bar Association who is and advised them to collect the certified copy of the title appeal. Accordingly, they have applied for certified copy of judgment only on 14/12/2021 and received the same the February. No, it is not believable.
That is there in the itself, my lord, in the judgment itself, your lordship may peruse.
They have not taken the proper instruction, your lordship.
My lord, that was applied, my lord, that is at page 34, my lord.
It is ready on.
Page 34, that is.
Let him complete. Yes.
Now, this is not the proper explanation why the delay. And he is saying that one person is in the army. But in this case, the petitioners are 13 numbers. And here, your lordship, if your lordship say the judgment of the year is 2019. And the title appeal was filed in 2014. Title appeal was filed in 2014 and judgment was passed 17/8/2019. And as they are party, this is not the ex parte judgment. They appeared, their advocate is here. Why they could not take the instructions from the earlier advocate? There are 13 numbers. They have explained only one person is engaging in this case. So that is totally clear also. So I have the strong objections. I have the strong objections.
You have filed objection here?
Yes, we have filed objection.
And I have also filed reply, my lord.
Okay. Heard Mr. Alam, learned counsel for the applicant, and also heard Mr. Upaite, learned counsel for the respondent, opposite party. Argument concluded, order reserved.
My lord, in this case, I relate 3 judgments, my lord. If you
Probably.
Item 25.
May I please, your lordship? Lordship, today the sole respondent has filed an affidavit in opposition.
Lordship will kindly fix the matter after 1 month, my lord. I need time to read the content.
No, this is an appeal. Is there any provision for filing any affidavit in opposition?
That is confirmed. The last date also we have submitted before the court. So for the factual aspect, if confirmed, we have filed affidavit in opposition. Considered lordship. And the record is also received lordship. That will be fixed for hearing.
Heard Mr. S. Vikas, learned counsel for the appellant, and Mr. Ullah for the respondent. The learned counsel for the appellant submits that the respondent herein has filed one affidavit in opposition, and he has received the copy today.
Today, my lord.
Today. And he prays for granting him some time. Where allowed, recessal is the matter for hearing.
Hearing. Highly
After March, in the month of March.
26.
May I please, Lordship? Lordship, notice upon respondent was not completed, Lordship. Service was not completed.
So you have
in the
taken
matter,
any step?
Lordship?
You have taken a step?
No, Lordship.
No. You want to take a step now?
Yes, Lordship.
Heard, Miss?
Armedhi.
Learned counsel for the petitioner. The learned counsel for the petitioner submits that she may be granted some time to take step upon the respondent. Where allowed, recessal is the matter. After 4 weeks.
Lordship, there is another matter in lower court, Lordship, where the date was fixed on 11/3/2026. Lordship may kindly list the matter on first week of March, Lordship.
Okay. No, but you have to effect service of notice upon the respondent.
Yes, Lordship.
You have to take step here.
Yes.
So
Step.
can you complete it within the first week of March?
Yes, Lordship. We will complete it.
Recessal is the matter in the first week of March, in the month of March, in the first week.
27.
Obliged.
My lord, here both the parties have appeared, so my lord, it needs a detailed hearing.
Hearing.
Yes. So,
Heard Mr. R.P. Sharma, learned senior counsel, assisted by Miss.
it may be admitted and my lord.
My lord, the matter has not been admitted here. My lord, today we are appearing to the first time for the respondent number 1 and 2. All the respondents, my lord. Matter may be fixed for admission hearing, my lord.
After the civil matter, my lord, it may be admitted and fixed for hearing. It will be cut the time short of the court also.
Assisted by Miss.
And Mora.
Learned counsel for the petitioner and Mr. G. Imtiaz, learned counsel for the respondent. You have for the respondent number 1 and 2.
Yes,
No,
sir.
1 and 2. List the matter for admission hearing. After.
In the month of March, my lord, if
In the month of March.
God willing, my lord, I may be there in the field or in the month of March or last week of March.
Last week of March.
Yes. My lord, the interim order may be continued.
Interim order passed earlier shall come.
My lord, likhit.
If
Interim order. In this case, my lord, service has been completed, my lord.
Service
The
completed.
respondents appeared.
So it may come up for admission and the interim may be continued by. There is interim, my lord, that may be
Okay.
continued.
Heard Mr. S. Sharma, learned counsel for the petitioner, and Mr.
For each time maybe given.
Boyce, learned counsel for the respondent. Respondent number 20. Oh, 2 entry, sorry. 2 entry. Mr. Sharma submits that since service has been completed in this matter, the same may be listed for admission hearing. Pair allowed recessal is a matter. In the first week of April? First week of April.
Interim, my lord.
Interim order passerly shall continue.
Similar, for each time maybe given for filing a petition opposition.
No, this is a CRPIO. Where is the provision for filing affidavit in opposition?
I cannot be sure.
Mr.
R. Sharma.
R.
R. Sharma.
R. Sharma, learned counsel for the petitioner, and also heard Mr. J.P. Boyce, learned counsel for the respondent. Since service in this matter has already been completed, recessal is the matter for admission hearing. In the month of April, first week.
Along with item number 28, Lord.
Okay.
Tag
Along with item number 30.
Interim order may be.
20. 28.
Interim order may be.
Interim order pass earlier shall contain.
Item 30.
May I please, your lordship, as per the office note dated 30/10/2025, respondent number 2, 3, and 4 are appeared, lordship, and respondent number 1 service not completed, lordship. Only issue fresh step, lordship.
Heard, miss?
Are they appearing on behalf of AR Shom, lordship?
Learned counsel appearing on behalf of Mr. Ayerson, learned counsel for the petitioner. None appears for the respondent number 2, 3, and 4. Though one learned counsel has filed Ogalatnama. Office note dated 30/10/2025 indicates that neither ID card nor unserved notice in respect of respondent number 1 received by the section till date. The learned, you want to take fresh step?
Yes, lordship.
Learned counsel for the petitioner submits that she may be permitted to take fresh step upon respondent number 1. Where allowed, step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Obliged, lordship.
31.
May please, your lordship. In this case, my lord, the service is complete, my lord. Since the parties have already appeared to their counsel, my lord.
Okay.
The interim order was till the returnable date, and that interim order may kindly be extended, my lord.
Heard, Mr. Insidas, learned senior counsel assisted by
J. Bush.
Yep.
J. Boyce, learned counsel for the petitioner, and Miss
K. Bora.
K. Bora, learned counsel for the respondent.
All the rest.
All the rest.
For all the respondents. Mr. Das, learned counsel for the petitioner submits that service in this matter has been completed and the matter may be listed for admission hearing.
I cannot pay for calling for the records, my lord, because so that the matter can be finally heard and disposed of at the admission stage, my lord. Original record of this commercial suit case number.
Original record is required.
That will be required, my lord. For finally dispose of the matter, my lord.
Okay. Interim order passed earlier shall continue. Mr. Das, learned counsel for the petitioner submits that this matter may be disposed of at the admission stage itself, and to dispose of the same, record of the learned trial court will be required, and as such, he submits that the record of the learned trial court may be called for. Accordingly, it is provided that registrar shall call for the scan copy of the record.
My lord, well,
Scan copy of the record of commercial suit number 4 of 2022. Urgently list the matter after 4 weeks.
my lord,
After 4 weeks.
obliged to your lord.
May please your lordship. As per last office note 11-2 lordship,
Hmm.
regarding respondent number 7 lordship, he could not be found in the given address lordship. Otherwise 1 to 6 my learned friend is here. So may I please lordship kindly grant me 3 weeks time to take fresh steps upon respondent number 7 lordship. After
Okay.
collecting his address lordship.
Heard Miss Bhattacharya, learned counsel for the petitioner, and Mr. Dutta for the respondent number 1 to 6.
Yes, sir.
1 to 6. Ms. Bhattacharya submits that service upon respondent number 7 is yet to be completed in view of the office note dated 11/2/2026, and she may be permitted to take fresh receipt upon him. Where allowed, recess shall list the matter after 4 weeks. 4 weeks or 3 weeks? 3 weeks? 3 weeks. Okay. Step be taken by speed post and also by usual process within a week from today. List after 3 weeks.
Earlier stay order lordship till today lordship, the 29-1, that may be extended.
Interim order pass earlier shall continue.
Obliged.
May I please, your lordship. In respect of respondent number 1 and 6, they have appeared, lordship. And 7 and 8, they are the pro forma defendant in the suit. Their name may be struck out, lordship. Because they are the main party.
Okay. Heard Mr. Kolita, learned counsel for the petitioner. And Mr.
Yes, sir.
S. Deka, learned counsel for the respondent number 1 to 1 to
6.
1 to 6. The learned counsel for the petitioner submits that respondent number
7 and 8.
7 and 8 are performer respondent.
Defendant.
Pro forma
It is
defendant.
not there.
Om Prakash Prasad and Ramdev Sharma.
Okay.
They are the pro forma defendant in the suit.
Ramdev Sharma. No, in the title, so there was a 7 defendants.
Yes, sir.
They were the pro forma defendant in the suit.
You come to page number 18.
So they have been expertise in the suit, lordship, because case is against me. I am the principal defendant. I have filed a petition under order 13 rule 10 calling us some record.
They have the main parties, yes.
Okay.
Then 6 and 7, they have main parties as the 7 and 8.
Okay. Mr. Kolita, learned counsel for the petitioner submits that respondent number 7 and 8 are performer respondent and their name may be struck off from the array of this petition. Any objection?
No.
Mr. Decker submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, the name of both the parties, it is provided that the name of respondent numbers 7 and 8 be struck off from the array of this petition at the cost and risks of the petitioner. Since service has already been completed, this is at least the matter for admission hearing.
A date may be fixed, lordship.
18 of 26.
Obliged, lordship.
And 34.
May I please, your lordship. I have for continuation of delay. Delay is 378 days.
Service completed.
Service completed. Petition may be disposed of.
Start করছে গেলে বা বন্ধন করাই নাই তো RSA নাম্বারটা বলে দিবে যে নাম্বার দিছি নাম্বার দেখো পেপার রাখো তো দেখাই দিয়ে তো ভাত Heard Mr. Bora, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant for condemnation of delay of 378 days in filing connected. A regular second appeal against the judgment dated 11/1/2024 and decree dated 24/1/2024 passed by the learned district judge M in title appeal number 9 of 2012. Mr. Bora, learned counsel for the applicant submits that notice upon all the respondents were served, duly served, but the respondent opposite party failed to but the respondent opposite parties remain unrepresented today. Mr. Bora further submits that where in which paragraph of your application you have explained the delay?
Yes, paragraph is paragraph 8.
8.
10 at page 10 and 9 also.
What is the ground?
Ground, actually, she has no knowledge about the disposal of the appeal. The other respondent is conducting the case by engaging the lawyers. But earlier, her husband was party.
You have not been represented by the council there?
Yes.
Then?
But they have not informed to the present petitioner appellant. And subsequently, he has come to know at paragraph 9, when the execution notice for execution proceeding received by her, then she moved the file and approached the trial court and obtained the certified copy, and then approached to me, and thereafter filed this present application along with the connected appeal. Paragraph 9 has specifically mentioned.
Mr. Bora, learned counsel for the applicant submits that though the applicant was represented by counsel before the learned trial court, before the learned first appellate court, yet she has not been informed about the disposal of the said appeal. And the said ground has duly been explained in paragraph number 9 and 10 of the application. And that the delay is not deliberate, and rather it is circumstantial, and under such circumstances, Mr. Bora has contended to condemn the same and to admit the appeal. Having heard the submission of Mr. Bora, learned counsel for the applicant, I have carefully gone through the carefully gone to the statement and averment made by the applicant in paragraph number 9 and 10. And it appears that the delay of 378 days have duly been explained. And accordingly, the same is thence condemned. In terms of this IA since dispose of, in view of the order passed in this IA, registered regular second appeal and list the same before this court.
Madam, will be
As
fixed,
soon
my lord,
practical.
end of this month, because first week of the month, the execution proceeding is fixed.
Your eye is there for staying. We'll consider at the time of admission of the appeal. As soon as practicable. Color is the body. ऐसा होया available this time around.
Please, Your Lordship. Lordship, my senior is lagging another court. Can it be taken up day after tomorrow, Lordship?
Tomorrow.
Tomorrow or day after tomorrow?
Yes, Mr. Talukdar.
I have some difficulty. It's maybe on 20th, my lord.
28th. Friday.
Friday.
Yes, agreed upon by learned counsel for both the parties. Release the matter on Friday.
Your Majesty.
40.
Lordship, IA number 1094, it is for the condonation of delay, Lordship, on restoration. The RSA was dismissed for default. I think respondents have no objection.
Once it was dismissed, but you are for all the respondents.
And for all the.
There is a delay of 296 days, Lordship. Actually, what happened, the earlier advocate, Raghavinda Borua's died in the year 2019, but parties are not informed about that. That's why this is a problem created. And during the COVID period, there was no communication between the advocate and the petitioner, Lordship.
Okay. Heard, Mr. Your name, please?
Z. Sharma.
Z. Sharma, learned counsel for the applicant, and Ms. Esral for the respondent opposite party. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 296 days in preferring the restoration petition against the order dated 4/3/2024 passed in RSA number 4 of 2010. Mr. Sharma, learned counsel for the applicant, submits that the earlier conducting counsel suffered demise during the period of COVID.
No, Lordship. COVID, 2019, Lordship. 18. 6/5/2018, he died.
Suffered in the year 2018. And the same was not informed to the applicant. And therefore, appropriate petition could not be filed in time. And there is no intentional delay. Rather, no, the delay is not intentional, and rather it is circumstantial. And as such, he contended to condone the same. Mr. Roy submits that she has no objection in the event of condoning the aforesaid delay. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so forthcoming for the delay, this interlocutory application stands allowed. The delay of 296 days in preferring the restoration petition against the order dated 7/3/2024 stands condoned. Passed in RSA number 4 of 2010 stands condoned.
Now, Miss case number 11.
Miss case number
11, only 2025.
Yes.
This is filed under order 41/19 for restoration of the RSA.
Heard Mr. Z. Sharma, learned counsel for the applicant, and Ms. S. Roy, learned counsel for the respondents. This interlocutory application under Order 41, Rule 19 of the Code of Civil Procedure is preferred by the applicant for restoration of the RSA number 4 of 2010 by setting aside the order dated 7/3/2024 passed in RSA number 4 of 2010. Mr. Sharma, learned counsel for the applicant, submits that the application for condonation of delay has already been allowed by this court in preferring this restoration petition. And as such, this interlocutory application may be allowed by restoring the RSA number 4 of 2010 by setting aside the order dated 7/03 of 2024. Ms. Roy, learned counsel for the opposite party, submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also the facts and circumstances on the record, this interlocutory application stands allowed. The order dated 7/3/2024 passed in RSA number 4 of 2010 stands recalled. The RSA number 4 of 2010 be restored to the file.
Yes, another IA there is. 111/2/2025. It is abatement and substitutional respondent number, appellant number 2, Lordship, Munindra Bhumi. He died and his wife is made party in this case, Lordship. There is a delay of 1834 days, Lordship.
Heard Mr. Z. Sharma, learned counsel for the applicant, and also heard Ms. Roy, learned counsel for the opposite parties. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 1,834 days in preferring application for setting aside the abatement and substitution of legal heirs and representative of the deceased. Appellant number 2, namely Munindra Bhumik.
Munindra Bhumi.
Mr. Sharma, learned counsel for the applicant, submits that Munindra Bhumik suffered demise in the year
Subsequent. 21/8/2019.
2019, Lordship.
21/8/2019. 21/8/2019. And that there is a requirement of bringing on record the legal representative of appellant number 2, namely Munindra Bhumik, in the RSA number 4 of 2010. 2010. Ms. Roy submits that she has no objection in the event of condoning the aforementioned delay. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record and the explanation so put forwarded for the delay of 1,834 days, the same stands condoned. In terms of this, I stands disposal. Next.
Next, Lordship, 11113.
It is for setting aside abatement.
Abatement. Is the
Heard
appellant number
Mr.
2.
Sharma, learned counsel for the applicant, and Ms. Roy for the respondent. This interlocutory application under Order 22, Rule 9, 2 of the Code of Civil Procedure, read with Section 151, of the Code of Civil Procedure is prepared by the applicant for setting aside the abatement against the deceased appellant number 2, namely Monindra Bhaumik, who died on 21/3/2019. So Sarma Learned Counsel for the applicant submits that the appellant number 2, namely Monindra Bhaumik, suffered demise on 21/3/2019. And on such count, the RSA number 4 of 2010 against the said appellant stands abated. And this abatement is required to be set aside as the legal representative of the aforementioned appellant number 2 are required to be brought on record. Ms. Roy submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. Abatement of the RSA number 4 of 2010 against the appellant number 2 stands set aside. Stands set aside.
There is
In
another
terms
IA
of this IA stands disposed of.
214. That's a substitution fee.
Heard Mr. G. Sharma, learned counsel for the applicant, and Mr. Roy for the respondent. This interlocutory application under Order 22, Rule 3, read with Section 151 of the Code of Civil Procedure, is prepared by the applicant for substitution of legal heirs and representative of the deceased appellant number 2, namely Monindra Bhaumik, who in RSA number 4 of 2010, as he suffered demise on 21/3/2019. Mr. Sharma, learned counsel for the applicant, submits that appellant number 2, appellant number 2, namely Monindra Bhaumik, suffered demise on 21/3/2019. And in his place, no. Who are the respondents? No, who are to be brought on record?
Arati Mondal, Arati Mondal, wife of late Monindra Bhaumik.
Where you have mentioned it?
In paragraph 5, page number 6.
Mr. Sharma submits that appellant number 2, namely Monindra Bhaumik,
Mondal.
no, Monindra
Arati
Bhaumik
Mondal
left
Monindra.
behind one legal representative, namely
Arati Mondal.
Aruti Mondal,
And his minor son Shiv Shankar Bhaumik.
and
He will
his
be also
minor son
represented.
Sri Shiv Shankar Bhaumik.
Bhaumik.
Shiv Shankar Bhaumik,
He will be represented by his mother, Arati.
who is a minor and is to be represented by his mother, Aruti Mondal. Aruti Mondal. Miss Roy submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, basically interlocutory applications that's allowed. The legal representative of the appellant number 2, namely.
I'm sorry, Lordship, there is another legal here, minor, Biki Bhaumik. Arati Bhaumik, Shiv Shankar Bhaumik, and Biki Bhaumik is about 10 years. The minor sons will be represented by Arati Mondal.
Behind Arati Mondal, Shiv Shankar Bhaumik, within the 12 years, and Biki Bhaumik 10 years. And they are required to be brought on record as a legal representative. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application that's allowed. Srimati Aruti Mondal Shiv Shankar Bhaumik and Vicky Bhaumik be implemented as appellant in place of appellant number 2. In place of appellant number 2. Since Shiv Shankar Bhaumik and Vicky Bhaumik are minor, they will be represented by their mother, Srimati Aruti Mandal. In terms of above this IA is disposed of. In view of the order passed in this IA, the learned counsel for the applicant shall file amended cause title of the RSN number 4 of 2010 within a period of 1 week from today.
The last, LCR may be called for.
LCR is returned, Lordship.
Yes.
LCR is returned.
LCR.
That is called for.
No, let the RSA be listed before this court. On that day, we will pass the order.
Lordship.
Lordship fix the date. Lordship.
Within a period of 1 week, you have to file amended cause title. And as soon as the case is listed before this court, we will call for the record.
Lordship.
Yeah, it's still.
24th February.
March.
February.
24th February.
Scheduled for admission. Number 8.
May I please, Your Lordship? Lordship, to be honest, this it is absolutely the discretion would be required from this honorable court in this case, Your Lordship. What has happened, Your Lordship, that I was the defendant in a suit filed by the respondents, the predecessor of the respondents. Now, when the case was fixed for DW, there was a delay on the part of the defendant in filing the DW, and because of which it was closed, against which a review was filed against that particular order, closing the DW, against which a review application was filed by the petitioner as the defendant, which was rejected, against which we have, before this honorable court, seeking interference from this honorable court with regard to that. The application, Your Lordship, because undoubtedly I want to say that there was a delay on the part on the defendant in filing the DW, though there were some in between issues because which the delay took place. But first of all, I will take Your Lordship, first of all, to the order by which we are aggrieved. And that order, Your Lordship will find at page 16, Your Lordship. And before that, Your Lordship may kindly come to page Annexure B, page 22. First, Your Lordship may take up page 22. Here, it is an order of 17/5/24, Your Lordship. Here, today is fixed for DW, heard the submission. This is a long pending case, such and such. Till pending stage of DW, the defendant has not adduced any evidence, even after a large opportunity was given by my predecessor on such and such. Then the learned counsel by petition sought adjournment for adducing evidence on next date. I have perused record thoroughly and found the pending DW since long. Moreover, previous order dated 31/21 and such, there are 2 opportunities were given by my predecessor to adduce DW. Yet the defendant side did not bother to adduce the evidence till date. It is pertinent to mention herein that on such and such, it has come to the knowledge that the instant suit is pending at the stage of DW since 6/1/18. Further, the last order directing the DW evidence, but it seems that instead of adducing, filed an adjournment today in order to delay the proceeding and such and such. After consideration, so by this order, the DW was closed, Your Lord. Thereafter, the petitioner filed a review application, and that was also rejected by the order at page 16, Your Lordship. Annexure A, against which we are before this honorable court. Both parties are represented by their respective counsel. By this order, to dispose of a petition number such and such, filed under order 47 rule 1, read with such and such. then it is pertinent to mention that the learned counsel have submitted an objection petition. This, I'll skip your lordship. Next page 17. As per petition number such and such, the defendant number 1 is aggrieved by an order dated 17/5 passed by the learned court in title suit number such and such, whereby the DW evidence was closed. Petitioner states that he ought to have submitted his evidence on the date fixed on this, which was the first date of DW. Petitioner also states that due to court remaining vacant, he had no knowledge of the new officer joining the court, and there is no fault or laches on the negligence, and thus prays before this court to review the said order dated such and such and accept the DW. I have gone through the objection filed by the opposite party. On perusal of the petition and objection, the court has observed the following. The said review petition filed by the defendant on 21/6/24, whereas the order passed by the learned court is 17/5/24. The review petition is filed beyond the period of 30 days without any condemnation. As such, that review petition is barred by limitation. Secondly, petitioner claims that the date of DW is such and such, whereas on perusal of the case record, it is revealed that the order dated 9/11/17, my learned predecessor had fixed the next date on such and such. Subsequent to the order passed by my learned predecessor, defendant was supposed to submit DW. Also, by order dated 31/21, my learned predecessor reflected that the instant suit is pending at the stage of DW since such and such, and thus considering the same, last opportunity was given to the defendant to adduce his evidence. Now, as regard to the order dated such and such, this court has already made it clear the instant suit is pending at DW since long, and after consideration, last 2 opportunities were provided by my predecessor, allowing the defendant to file the DW evidence thereafter, proceeded to reject the adjournment petition, considering the long pendency of suit at the DW stage. Therefore, in view of the above, it has come to the conclusion of the court that the prior order of this petition has many opportunities at hand to submit his evidence in affidavit, and the DW evidence was not fixed for the first time on such and such. It was fixed this from between such and such. And as such, the petitioner, due to his own negligence and lack of due diligence, failed to adduce the DW evidence in affidavit on the fixed date, and which is nowhere related with the petitioner having knowledge or information of the presiding officer joining the court. Further, it is the duty of the defendant to be vigilant about his subsisting right, and the law assisting those who are vigilant, those who slips over the right. So by this order, your lordship, this the DW was closed, your lordship.
Dismissed.
So we are before this honor because a valuable right is being lost, your lordship.
No, that's not right. But how many adjournments you have availed there for
Lordship,
filing DW?
I think
12 years.
12 years.
Yeah.
not 12 years as such, your lordship. There were in between, but if your lordship sees that thing, no, he has brought the record. The PW was closed
13 years.
from 2018.
2013.
Thereafter, a revision petition was there.
That was also filed before this honorable court. That was also dismissed.
Initial stage, there was a revision. So I won't,
2015.
I don't dispute that what is there. So as I have stated, your lordship, it is absolutely a thing which a petitioner before your lordship craves, your lordship, that whatever means a valuable right, because there was undoubtedly some delay, but as your lordship knows the trial, because he will get opportunity to cross-examine the witness, etc. So even if your lordship feels appropriate cost may be imposed to allow this, your lordship, but what I'm saying is a substantive right will be lost if the evidence is not allowed to be adduced, because WS is on record, your lordship, and I won't try to justify what is there on record, but the thing is, your lordship, a substantive right is
You
there.
could not file your WS also.
Yes, we have filed it.
You have filed.
Yes, it is on record. Everything is on record, and there was I don't want to say, your lordship, the thing is there, he will reiterate what is there in the WS, and the plaintiffs are obviously be allowed to cross-examine. Now, what I say, your lordship, as undoubtedly there is delay. But a right to lead evidence is there, your lordship. So if it is allowed, your lordship, no doubt there is a delay and that can be compensated by giving any adequate cost as may be imposed by this honorable court. But at least he may be allowed to participate.
Whether any stay is granted here?
Pardon, your lordship?
Any stay is granted here? Is the proceeding is stayed?
Yes, your lord. And as per my information, your lordship, the evidence was filed. Okay. I think the last opportunity was taken for filing the evidence, your lordship. And though any date may be fixed by your lordship for filing with adequate cost, whatever your lordship may please, your lordship. I won't say that there was no delay as such.
Yes, goes.
In this case, on 31/8/2013, the plaintiff evidence was closed.
31?
31/8/2013.
Hmm.
And 2 of 1995 of 2005. Then on that day, 27/9/2013, date fixed for DWs.
27?
9/2013.
Okay.
Then the defendant took stand on 10/11/2014, 3/12/2014. Then thereafter, they have filed a civil division 232 of 2015.
No, that's all right. Now you tell me, he is ready to pay some amount of compensation.
My lord, kindly see the conduct.
No,
Yes,
that's all
kindly
right.
see the conduct. If conduct, it is your up to your lordships. Now see conduct from
No,
2013.
I am asking you what is your stand upon this point, that he is ready to pay some amount of cost.
This order of PW was closed and fixed for DW. That order was challenged before this honorable court. That was dismissed. That is why I am saying, my lord. Then thereafter, your lordship, kindly see the order. Only thing, the last part of the order is that it will proceed accordingly. So again, it has been after dismissal, it has been fixed for DW.
Okay.
That order.
Okay. Okay, we will pass the order.
And this is the order.
Hand over it. Court.
Highly obliged, your lord.
My lord, this petition filed, my lord, challenging the judgment of REAT, my lord, Real Estate Regulatory Authority, Appellate Authority, my lord, dated 6/2/25. The order is at page 72.
Last page.
Lordship, at this stage, my lord, we have raised substantial question of law, my lord. Lordship will issue notice, my lord. Page 72 is the order. The three appeals were disposed of with the common judgment, my lord. That is case number 6, appeal case number 6, 7, and 8. Lordship. Main issue is this, my lord, whether deemed occupancy can be, my lord, if the deemed occupancy is there, my lord, RERA has come into effect, my lord, with effect from 1/5/2017. And occupancy certificate applied on 3/10/3/2016. So whether that the issue will come within the purview of RERA or not.
That is that. I have sufficiently demonstrated, my lord, that that the construction was not complete by that time, my lord. Lordship may see the annexure 1 at page 25. Because the construction was, my lord, the Dibrugarh municipality had issued a stop construction notice, my lord, to the builder, my lord. Illegal construction, lordship may see
Page
page
number?
25.
25.
Page 25, my lord. Second para, my lord. Hence, this is to the builder, my lord, as Assam State Developers Private Limited. Hence, you are hereby asked to stop construction of the said hotel from immediately from the date of receipt of this notice, failing which, my lord, he has taken permission for to make office, my lord. And then, my lord, instead of office, my lord, he had constructed hotel in that particular place, my lord. So, Dibrugarh. This was issued on 6/10/2020, my lord. And RERA has come into effect from 1/5/2017.
Second letter.
Then second letter, my lord, lordship may see at page 26, revised drawing. This revised drawing also on 13/10/2020, after the RERA come into effect, my lord, 1/5/2017. Then, my lord, lordship may see the third annexure, my lord, page 30. Page 30 is the application for occupancy certificate. Then page 35, lordship may see transformer, he has applied page 35, my lord, annexure 4. Transformer, he has applied in 25th April 2018, whereas his occupancy certificate is 10, his occupancy certificate is on 10/3/2016, my lord. After he receipt of the occupancy certificate, after he submitting of the application for occupancy certificate, he applied for transformer, my lord. So we want to highlight that, my lord. By the time RERA has come into effect, my lord, he will come within the purview of RERA. So deemed certificate will not be applicable in that case, my lord. So lordship will issue notice at this stage, my lord. And substantial question, lordship will see at page, my lord, 21, my lord. May I read, my lord? Number A, whether on the facts and circumstances of the case, the real estate project, namely Orchid Residency, fell within the scope and ambit of Real Estate Regulation Development Act 2016, and consequently whether the complaint case filed before RERA are maintainable. Number 2,
No, that's all right. This act is of 2016.
Act is of
And when it came into force?
1/5/2017.
2017.
17. So I want to, I've already shown, my lord, that after RERA came into effect, they have applied for electricity, they have applied for lift, so the project was not complete, my lord. But by fraudulently, he has shown that application is made on 10/3/2016. And my lord, I made RTI also, my lord. Lordship may see RTI reply, my lord, at page 39. Here, my lord, 26/10/2022, serial number 6 may be seen, my lord.
Page number 32.
32, 39. Serial number 6, my lord. Occupancy certificate is not issued yet, my lord. Then next, my lord, page 7, also annexure 7, page 40, my lord. Yes. Number 1, my lord, no application have been received by this office from Messrs. Assam State Developers Private Limited seeking occupancy certificate in respect of Orchid Residency at Pansi so and so. This is given on 23, my lord, and his application, lordship will see that he made on 10/3/2016, which is at page, my lord, 30. this is annexure 3 column, my lord. He made application for occupancy certificate on 10th March 2016, whereas on 2/11/2023, the authority said that no application has been received. So there is, my lord, lordship has to look into all this, my lord. So my entire case was that, my lord, that occupancy certificate fraudulently he has made, and then he want to show that he doesn't come within the purview of RERA. So that's why, my lord, because RERA has come into effect from 1/5/2017. So somehow he made an application on 10/3/2016, and it admittedly, my lord, from the record, it's seen that he received, he had applied for transformer, he is applied for lift after that, my lord. So the project was not complete. Now, learned court observed, my lord, at page 10, my lord, para 10, page 80.
Okay, pause for a moment. So, according to you, the real estate tribunal has the jurisdiction.
Has the jurisdiction. Yes. And observation is there at para 15 of page 85, how the tribunal has dealt that this is not maintainable, my lord.
Okay. I think this substantial question number 1 and 2, this question number 1 will be sufficient, I think. It will cover almost all the questions.
Yes, one will be, my lord, but as yes, correct. One is the substantial question law, one is.
Okay. Heard Mr. Roy, learned counsel for the senior counsel, assisted by Mr. Learned counsel for the appellant. This appeal under section 58 of the Real Estate within bracket Regulation and Development Act 2016, read with section 100 and order 42 rule 1 and 2 of the Code of Civil Procedure is directed against the common judgment and order dated 6/8/2025 passed by the learned Real Estate Appellate Tribunal Assam in appeal number read stroke Assam stroke appeal number 06 of 2025, comma read stroke Assam stroke appeal number 07 of 2025 and read stroke Assam stroke appeal number 8 of 2025, whereby whereby the aforementioned 3 appeals were dismissed by the learned tribunal for want of merit. Want of merit or is it for want of merit? Court has not decided in on merit. The tribunal has not decided the appeal on merit.
The merit not decided. It was held that it is not maintainable, my lord. Last technical last para 15, page 85. in this last, para 15, last 4 line, my lord, in this view of the matter, para 15, my lord, 85, page 85.
Dismiss the appeal by holding that the appeals are not maintainable for adjudication before the RERA. But in that case, you have to amend your cost title. You see page number 2. Dismiss for want of merit.
Oh, that is, my lord, want to merit.
Huh?
But, lordship, I will correct it, my lord.
Okay. Peruse the memo of appeal, the grounds mentioned therein, and the suggested substantial question of law, and also peruse the impugned judgment and order dated 6/8/2025. It appears from the operative portion of the impugned judgment and order that, especially from paragraph number 15, that the learned tribunal has dismissed the 3 appeals on the ground by holding that the same are not maintainable for adjudication before RERA. In exercise of the power under the Real Estate Regulation and Development Act 2016. 2016.
Lordship, para 16 may be seen, my lord. Honorable court had said, my lord, from the foregoing discussions and findings, all the 3 appeals are dismissed for want of merit. I think that is the language.
It's contradictory finding. Once you are saying it is
Uh,
not maintainable.
But not maintainable, and merit has also been discussed.
And also by holding that the 3 appeals on the also for want of merit. Holding it not maintainable for adjudication and also for want of merit.
Merit, right.
Want of merit. This second appeal is admitted on the following substantial question of law. Then there will be 2 substantial questions.
A and B, my lord.
A and B. Issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Registrar shall call for the record from the learned tribunal. Place the matter after 4 weeks.
Oblige.
Hearing order 41, become 12.
Wait, please, Your Lordship. Lordship, may kindly pass over the matter for the day.
You are for?
I am appearing for responding 2 and 3, secondary education.
In title appeal.
Yeah, earlier didn't close us, Your Lordship. Now they made
Okay.
2 and 3.
2 and 3.
Like
Hard,
it's a-
hard miss.
S. Ajmi.
Learned
behalf of
counsel for the appellant and Miss P. Das, learned counsel for the respondent number
2 and 3.
2 and 3.
Otherwise, Your Lordship, this well settled, Your Lordship.
Yes.
Well settled law is there, Your Lordship, page 90.
Mm.
This petition, Your Lordship,
Mm.
the legal proposition in this regard
Mm.
onwards, Your Lordship.
Okay, today the conducting counsel is absent. Let it be on some other day.
Yes, sir.
The learned counsel for the appellant submits that appearing for the appellant submits that conducting counsel. Who is the conducting counsel? Who is the conducting counsel?
Roshanara Chaudhary. R. Chaudhary.
R. Chaudhary. She is not present in the court today.
She is in another court.
Is Legs in another court, and as she pays for listing the matter on some other day. They are allowed. This is a list the matter after a week.
Obliged.